Hello and welcome to Sable International's webinar series on obtaining UK nationality through former UK colonies or territories. Today we'll be looking at links through Australia and just some housekeeping before we begin. We will be having a Q&A session at the end of the presentation. On the top right hand side of your screen you'll see there's a chat box which you can post your questions which we can answer. I am going to be posting a format which we'd like you to please ask your questions in. It will ask you to put your name, your place and date of birth, and your parents and grandparents' places of birth. And then please, if you can put all the information before hitting the send button so that we can get all your information in one neat post. It will be helpful for us to answer the questions more accurately. If you'd like to increase the size of the presentation, there on the top panel, there are arrows that are pointing away from each other. If you select those arrows, it will either make the presentation full screen or make it smaller. Also, if you'd like your presenters panel to be made bigger, there's a plus and minus button that you can use to change the sizing. We also have a poll going. The current poll is, what is your closest link to the UK? We'd like to see, it'll be interesting to see what the closest link is on this webinar. So just a little bit about Sable International, for those of you that don't know. We've been in operation since 1995, and we have offices in Australia, 2 in South Africa, in the United Kingdom, and a presence in Portugal. We have 6 core services that we specialize in, and we believe that these core services encompass vital aspects of our clients' needs that they have when investing offshore or moving abroad. Those services are tax advice, forex, foreign exchange, residency by investment programs, accounting assistance, wealth management, and then of course British nationality, citizenship and immigration. Your presenters for today, my name is John Dunn. I'm the Sales Director of the Citizenship and Immigration Division at Sable International. We have Philip Gamble. Philip is a founder and senior partner at Sable. He trained with the Home Office within their Citizenship Directorate until 1992 and is widely regarded as the foremost authority in the world on British nationality law. We also have Michelle Patel. Michelle was born in Mombasa, Kenya, and relocated to the UK in 2004. Michelle joined Sable International in 2009 and is registered with the OISC. Michelle specializes in isolating claims to British nationality for those who have connections to former British territories. So without further ado, I'm going to hand you over to Philip and Michelle to start the presentation.
Okay, thank you, John. Good morning from London. And as my colleague John said, we're going to talk today about applying for British nationality through connections with Australia and other former British territories. So before we start off, I think it's a good idea for you to get an idea of what we do on a day-to-day basis, how we calculate or establish these claims to British nationality for our clients. So on the screen, you'll see a slide detailing the status of Australia, or headed up the status of Australia. And what we do is we look at your family trees and we apply law that was in force at the point certain key dates in the past took place. So this might be the birth of an ancestor, or independence of a territory, possibly marriage of an ancestor, and indeed where your ancestors lived. So we're looking at the legislation that might be in force at, let's say, at the point when your father was born, what forms of UK nationality he may have acquired by operation of that law at the time, whether any later legislation has changed that, and whether that status can pass down to the next generation. So that's what we call a status trace, and it's about establishing what was there in the past and how that comes down to further generations born overseas in the modern day with a view to acquiring British nationality. As you can see from the slide, the status of Australia is listed as being within the Crown's dominions up until the 31st of December 1948, and as an independent Commonwealth country there afterwards. this is for the purpose of British nationality law only. Those of you who know your history of Australia will know that it was a self-governing territory for considerably longer than just simply from the 1st of January 1949. So this is for British nationality purposes. Other key dates in nationality law for the UK are indeed the 1st of January 1949, which is when a key piece of UK legislation comes into place controlling colonial nationality from the past, the former empire days. And in the modern day, the 1st of January 1983, which is when our British Nationality Act 1981 comes into force. Okay, so that's in a nutshell basically what we do and how we establish these claims. Quick note on Australia, there's no issue with dual nationality between the UK, Australia and Ireland, which are the three key countries involved in this particular seminar, which means that if you have a claim to British nationality, it won't have any effect on your existing Australian citizenship. So there's no problem in carrying two passports, one from the UK and one from Australia in the present day. Hasn't always been the case. The laws in Australia were quite restrictive up until about the year 2000, when dual nationality wasn't actually permitted. So people in the past weren't so lucky. And although dual nationality is permitted in essence, as you've probably seen from the news over the last few years, that if you are an Australian and wanting to run for Parliament over there, then you can't be a dual nationality under those circumstances. So it's dual nationality for most purposes, but not public office. Okay. So again, moving on from there, in terms of general matters in the past, you saw that the status of Australia in British nationality terms changes in 1949. So before 1949, anyone born in any of the Crown's dominions or the British Empire, former British Empire in the past, is what we call a British subject. So that is a form of UK nationality. In fact, it's the first form of statutory British nationality we have. This status was passed by descent in the first generation always, and sometimes in the second generation and third. When the 1st of January 1949 comes along, there's a change. Most of the larger Commonwealth countries are establishing their own identity, and local citizenships are formed. So citizenship of Canada, New Zealand, South Africa and Australia are formed all in this period. And generally speaking, British subject was lost, status was lost at this point. So what you can take from that is that to have a claim to UK nationality now in the modern day, you're probably going to need a connection to another country outside of Australia, either the UK or perhaps another place which remained under full control of the UK after 1949. So places like that would be like Kenya and Hong Kong. So there's a difference between self-governing territories, which are quite effectively introduced their own citizenship in 1949, and other places which remained under full UK control until much later, usually around the 1960s. So we're going to be particularly looking for you having ancestors born in either the UK or other British territories to gain rights to citizenship now. As you can see from the last point on this particular slide, all claims are subject to, or all claims by descent are subject to the parent not having lost British nationality before the next generation are born. So this has to flow down the generations, and if your father has renounced British nationality before you were born, that's going to be a problem now in the modern day. Okay, so onto some mechanics on how people actually qualify. So the most obvious way in which people qualify for UK citizenship is simply by birth. So on the slide, the examples given are birth in the UK before the 1st of January 1983 and birth in the UK after 31st of December 82. So citizenship it comes in two forms when we're looking at this, those born either side of this particular law change. If you're born in the UK before the 1st of January 1983, you're very likely to have a claim to UK citizenship without any further criteria needing to be met. So at that time, in the past, simply being born in the territory just gave you that right to citizenship. And indeed, it was the same with Australia as well, until more recently. So in the old days, effectively citizenship's given directly through birth and no other criteria needs to be met. As you can see here, the only exception is if the parent, one of the parents, or usually the father in this particular period, was in diplomatic service of another country at the time the child is born in the UK. So after the 1st of January 1983, the position changes. At this point, you don't just get citizenship by being born in the country, or in the UK in this case. You've got to have a parent who's also a British national or holding what we call a settled status, which in general split terms is what most people would call permanent residence. For those that are born in the UK after 83 who don't have a parent with that status, if their parent later acquires that status before their 18th birthday, then an application can still be made to the British government for that child to acquire British nationality later, so after the point of birth. But applications of that nature have to be made before the 18th birthday. So that's simply citizenship by birth, two different varieties, depending on when you're born, whether it's before Jan 83 or after. Okay, not surprisingly, the next thing you would think of in terms of citizenship after birth is citizenship by descent. So again, this has changed much over the course of time. The slide here displays some of the possibilities for citizenship by descent if your parent is born in the UK. So again, we've got key dates coming into play. So firstly, if we look at citizenship by descent in the father's line, under the original legislation of the UK, it was only possible to claim if your parents were married. So if you were born using the old-fashioned term illegitimately, that was a problem. This has been rectified now. Further legislation has been brought into force, changed in 2006, as you can see from the notes here. If you're born outside of the UK to a father born in the UK and your parents weren't married and you're born after the 1st of July 2006, that's okay. You still have a claim to British nationality in the modern day. If you happen to have been born before that date in the same circumstances, and so you didn't originally acquire citizenship by descent because you were born illegitimately, the law allows you now to make a claim to acquire British nationality through a formal application called registration. So those that were affected by this discrimination in the past can now make claims in the modern day and make applications for citizenship, whether they're born illegitimately or not. On the mother's side of the family, again, pretty much the same thing existed. Unfortunately, before the 1st of January 1983, it wasn't possible to claim citizenship by descent if your mother was born in the UK or your mother was British. You could only claim if it was your father and if you were born legitimately, as you saw. Again, more recent legislation has been brought in to give a remedy to this particular position. So if you're born after the 1st of January 1983 and your mother was born in the UK, then you have a claim automatically to citizenship. If you were born before 1983, again, because the law at the time didn't allow you to claim because of if you like gender discrimination at that time, a formal application has to be made in the UK to acquire citizenship through registration now. So that's two areas of recent change, allowing more people to qualify. As you can see, most of these solutions so far require a connection to the UK itself. If you have connections to other places which remained British colonies in the post-1949 period, like Kenya or Hong Kong, or the Seychelles and dozens of other places too, then claims are equally possible. So it doesn't always have to be a connection with the UK. It could be another UK colony. Okay, citizenship by marriage. Most people don't realize that in the past that a woman would acquire the husband's citizenship on the point of marriage. So you've got a position where if a Australian woman, a woman born in Australia, whose parents and grandparents were all born in Australia, marries a man before the 1st of January 1949, and that man happens to be born in the UK or acquires British nationality by descent, then that woman automatically acquired British nationality on her wedding day. So no application was required. It was just something which happened by operation of law at the time. And those women can acquire British nationality and a British passport directly now. It didn't work the other way. So the husband couldn't derive status from the wife at that point, and there's been no further legislation to make that gender equal. So this still affects women only, gives an advantage to women over men. Now, you're probably thinking, well, that's a long time ago. You know, that's 70 years ago. So who's going to qualify for that? And maybe they'd be in their 90s, perhaps, at the youngest point. So it might seem like an empty vessel. However, this isn't the case, because when we look at citizenship in the second generation by descent, we have to look at your parents to see if you've acquired or see if they've acquired British nationality themselves. So we've moved on to the next slide, and that shows the first example of citizenship by double descent. So this is in the second generation by descent. So on seeing that, you'll see that your paternal grandfather must be born in the UK for you to qualify. Your father must be born outside of the UK. This in Australia, probably in this particular context. And your mother is also born outside of the UK. So what we discussed in the last slide is that a woman who marries a British man before the 1st of January 1949 acquires that man's UK nationality if he's British or of British descent, as is the case here. So when the legislation was created to address gender discrimination in the past, it was probably overlooked the fact that the woman could acquire citizenship through marriage. So in this context, although if you looked straight down the male line, the applicant here born between 49 and 82 in perhaps Australia wouldn't have a natural claim to UK citizenship, because the mother's acquired citizenship through the father and acquires citizenship in that way. That then does or would have passed down a further generation by descent if the law had allowed it at the time. So you get this anomaly where citizenship can pass down in the second generation by descent when the mother's acquired citizenship through marriage to the father. Okay, so you'd be forgiven for thinking that if the mother acquired citizenship through marriage to a British man, she would lose that status if she then divorced. UK nationality law doesn't always follow a common sense principle, and in fact, that's not the case. So you get a bizarre situation occurring sometimes where if your mother was previously married to a British man, she then divorces, later marries your father, and you're born of the second marriage, then you can acquire citizenship through effectively your mother's first husband, who is not your father, if that makes any sense at all to you. And you'll get an idea that some of this stuff by now is, as I said, doesn't follow common sense whatsoever, and you'll get some very obscure claims coming up. So that's our first example of citizenship in the second generation by descent. The next one that comes up quite frequently with people that we see in Australia comes through what we term as Crown Service. So on this occasion, you've got an applicant being born after the 31st of December 1982, parent born in another country, grandfather born in the UK, in Crown Service. That means UK government service or colonial government service in another country, and that employment or that service being effective at the point the parent is born. So important point to note here is that Crown Service in Australia doesn't help here because Australia was a self-governing territory within the British Empire. So this only affects claims where the Crown Service is in a country which is under full control of the UK. So, for example, we see many members of the former Kenya Regiment who moved to Australia after independence of Kenya in the 1960s, settled in Australia. Next generation down from those guys normally qualify for citizenship. Same thing applies to the Hong Kong police and a large number of other territories where there's been movement and migration into the UK. So citizenship in the second generation by descent is worth looking at if you have ancestors who were in the civil service or former colonial service in another country apart from Australia. Okay, at this point, the further citizenship by descent solutions or criteria, I will hand you over to my colleague Michelle, who's going to take things from here for you. I hope you found that interesting.
Thanks, Phil. Hi, guys. Thanks for coming on to this webinar. I'll cover the next sort of 8 slides. And the first one you see here in front of you is citizenship by double descent colony. So I think Philip touched on this earlier, when he mentioned Kenya, Hong Kong, Seychelles as previous UK colonies. Now, in this case, you can see the nearest UK connection is actually the grandparent that's born in the UK. And where you have a parent born in a former UK colony or British colony. Now, what ends up happening here is you get the applicant also born out of the UK, of course, but the nationality derived from that grandparent and from the parent's own birth in a UK colony translates to that nationality passing a further generation to that applicant who also is born out of the UK. I mean, key dates here do matter, and you do have to take into account independence arrangements of the colony that the parent was born in. So sometimes where the grandparent is a grandfather or a grandmother as compared to grandfather, I should say, there is a slight change in the way of thinking, but in over sort of 99 or 95% of those scenarios, the claim still exists. And that it only comes to fruition because you have the parent that's born in that former UK colony, and ideally, this former British colony should be such a place that remained a British colony, ideally after 1st of January 1949, which is why we mention quite purposely Kenya colony, Seychelles, Mauritius, and so on. So that's one fairly straightforward double descent claim that would give rise to the applicant being eligible for a British passport in the modern day. So next slide. So here we have a slightly different scenario. So you've seen here in this slide, we don't use the word colony, we use the word British protectorate. Now, British protectorate was just another form of British territory where there was a local ruler in force, and the British were in treaty with that ruler. I think some of the main examples of places like this that come to mind is Nyasaland, which is now Malawi, Northern Rhodesia, which is now Zambia, and Kenya Protectorate, mainly Mombasa on the coast. There are a few dozen other places. But in this scenario, where the applicant is born before 1st January 1983 with his father or mother born in a British Protectorate and the grandfather born in the UK, again, you get a scenario where that grandfather's British nationality passes 2 generations. And in the modern day, that applicant would actually be entitled to a British passport. Now, it's important for us to also take into account the independence arrangements for that British Protectorate, because at times some of the independence arrangements are harsh and they do take away British nationality on independence. So if you are someone in this webinar who has a parent who was born in a former British Protectorate and you are born before 1st January 1983, then this claim could be potentially one for you. Now, where the applicant is born after 1st January 1983, again, they are rare, but we do see claims with the same sort of connections here. obviously the parent must, in that case, be born before 1st of January 1949. So again, it's very, very much based on dates. Even though the applicant is born on or after 1st of January 1983, for the claim to work, his mother or father should have been born in a former British protectorate before 1st of January 1949. So sometimes it's just about dates and not just the place of birth. So here we have citizenship by double descent, section 7. So Philip touched on this earlier, where he mentioned that in the period before 1983, the law was, it didn't allow females to pass on British nationality. So there was a big element of gender discrimination. And the UK government were, quite aware and became quite aware of that issue towards the end of the sort of getting up to 1983. And they knew that, I think, on 1st January 1983, they wanted to make things gender equal. And getting up to that, this was their first attempt to correct the gender discrimination faced by those born before 1st of January 1983. And in light of trying to correct that historic wrong to those born before 1983, they introduced a policy where they asked their British spouse abroad to register minors as citizens of the United Kingdom and Colonies through a UK-born mother. So often we find where, in a scenario like this, where the applicant is most likely born after 1st of January 1983 outside the UK, the parent also is born outside the UK, but the relevant grandmother is born in the UK. And now in a scenario like that, we see that the parent has a British passport, but not to the grandfather, actually to the grandmother here, or the parent's mother, I should say. And that's because, again, that parent or that mother has taken advantage of that policy that came into effect in sort of Feb 79, and has registered that parent as a citizen of the United Kingdom and Colonies. Now, that specific type of registration means that on the 1st of January 1983, where that parent has been registered prior to that date through their UK-born mother, that parent is actually reclassified as British other than by descent, which means, in a very brief way of saying, that they're allowed to pass on their British nationality to any children born after the UK, after 1st of January 1983, of course. So again, an applicant in this scenario could have a claim to a British passport in the modern day, where their nearest connection is actually their paternal or maternal UK-born grandmother. So another very varied claim there. Quickly jumping on citizenship by double descent under Section 3.2 of the current legislation, I noticed that there were quite a few questions on this one, and in particular, I think I made a note of someone called Sean. I think, Sean, if you're still on this webinar, this slide is applicable to you. And in this particular section 3.2, we have a option for children under 18 whose parents are British by descent, and the parent has spent 3 years in the UK with no more than 270 days out of the UK in that 3-year period, to then be able to register his or her child as a British citizen in the modern day. Now, an element of this requires the relevant grandparent, i.e. the relevant parent's parent, to be born in the UK or be classified as British other than by descent, which is quite easily done when you're born in the UK. So again, this is specifically for children under 18. So at the time of the application, your child must be under 18, and you must prove that you held British nationality at the time that child was born, and that you, as a relevant parent, have spent 3 years in the UK at any point in the past, but before the child's birth, and you're within those 270-day absence limit. So a registration in this case would not need any UK residence for this child, and an application could be done whilst the child and the family are actually based out of the UK. So that's another provision. So right to abode, this is not anything to British nationality, but it's the next best thing to British nationality. In this particular set of circumstances you have on this slide, the right to abode is actually passed automatically onto a woman just because she's a Commonwealth citizen, Australian in this case, could be quite relevant, and her marriage took place before 1st of January 1983 through a husband who is either born in the UK perhaps, and that's how he's British, or perhaps his dad was born in the UK, or in fact, he may have even lived and naturalized in the UK. It really doesn't matter, but as long as the relevant husband is British at the time of the marriage, and the marriage before 1st of January 1983, and the woman has always held Commonwealth citizenship. Now, the right to abode is an endorsement that's placed, so although it's given in law, you can claim it in terms of proof, and it's actually placed onto the person's Commonwealth passport, and it stays with that person as long as they're a Commonwealth citizen. Again, it allows visa-free entry to the UK. You can work here without any time restrictions. You can even settle here without any time restrictions, and you don't lose it if you stay out of the UK at all. If you are in the UK on the right to abode for 5 years continuously, if you're married to a British citizen, that is reduced to 3 years. You can look forward to naturalizing as a British citizen. So again, a lot of people may have this claim, but just don't know about it. Adoption. Again, I made a note of someone called Amanda, who's on this webinar. She mentioned her mother was adopted in the UK, which I think is quite relevant to you, Amanda, here. So with adoption, now adoption itself, especially when it's happened out of the UK, does not give any rights to British citizenship. If the adoption had happened in the UK, that's a different story, and one can look at a way to claim British citizenship. So even if you are adopted and your adoptive parent is born in the UK, and that's how they're British, unfortunately, it won't give rise to British nationality. However, it would give rise to what I described earlier, which is the right to abode. Now, like I said, it's the next best thing to British citizenship. So you can look at going ahead and trying to claim that, perhaps, if you're adopted, you're Australian and your adoptive parent is a UK-born citizen. Now, what I must also make you aware is there are claims to those under 18 who are adopted by British parents. So where a person, say, a parent is born in the UK, adopts a child, and the child is still under 18, the Home Office or the UK government are allowing us to register that child under the discretionary provision within the current law as a British citizen. Of course, it is quite complex, and they look a little bit beyond why the adoption took place. It's more about where it took place and what kind of adoption practices were used. Okay, so that's mainly adoption in a nutshell. So coming away from British nationality and permanent rights to the UK, we come into UK immigration. A hot topic at the moment, given that the UK are leaving the EU in less than a month. So, these provisions do become a little bit more important. So we've summarized 4 main categories, and I'll just go through them ever so quickly. The 2-year working holiday visa, very well known, I believe, in Australia. But again, you've got to be aged between 18 and 30, be a Commonwealth citizen, and you'll be given a 2-year working visa to enter the UK, work for anyone for that matter for those 2 years. Now, what has changed as compared to time gone by, and in fact that change in law has come in today, I believe, is that anyone on a working holiday visa or a 2-year working holiday visa in the past, or yesterday, I should say, going backwards, had to leave the UK unless they were given an option, unless they got an option to get sponsored work in the UK, and where they got that sponsored work in the UK, which I'll come to in a bit later now, they had to leave the UK and come back in and apply for the visa from out of the UK. Whereas from today onwards, you can switch into that category within the UK. You don't have to go out and come back from Australia. Again, so I think it's a good sort of stepping stone into the sort of work permit route, which I'll touch on in just a bit. The ancestry visa, a lot of people on this webinar may not have a claim to British nationality, but will have a claim because they have a UK-born grandparent to the ancestry visa. So again, the ancestry visa is a working visa, so you can't sort of come in and study on it full-time, so there must be an element of work to be undertaken. It is open to all those who are Commonwealth citizens with a UK-born grandparent, not a grandparent born in a previous UK territory, but must be born in the UK. Again, it can even be a UK-born grandparent in the adoptive line as well. This gives rise to a 5-year visa where you're successful. It's one of the very few visa categories that still, sort of translates into a full 5-year visa being issued. And within those 5 years, again, you can work for anybody. At the end of the 5 years, you have the option to apply for indefinitely to remain, which is our version of permanent residency, and then naturalize as a British citizen thereafter. I should add that you are also allowed to bring in dependents on this visa, so children under 18. If if you have a spouse, you can bring him or her in. And in fact, if you're not married but you're an unmarried partner, you can even bring that partner in, as long as you can ensure cohabitation between you guys for 2 years. So that's ancestry visa. The spouse visa, very straightforward, as the name suggests. Those who have permanent rights to the UK, perhaps you have the right to abode, or you have indefinite to remain, or you're a British citizen, and you want to bring your family into the UK, but your husband or your wife is not British, you would be looking at the spouse visa as an option. Again, the spouse visa is it used to be a 2-year visa, but now it's a 5-year route. So initially, you'll get a 2.5-year visa to join your British spouse in the UK. At the 2.5-year mark, you'll extend that for a further 2.5 years, thus qualifying under the 5-year qualifying period. And then you could do the traditional thing, which you apply for permanent residency or indefinite to remain, as we call it, and then naturalize straight after. One thing I will say about the spouse visa is, again, as a holder of a spouse visa, you can work for anybody in the UK. And you are obviously entitled to bring in children as well on that as your dependents. So the person holding a spouse visa can bring in children under 18 as his or her dependents. So that's the spouse visa. Work permit. So the work permit, or as we now call it, a skilled visa, very much based on the Australian points-based system, I should add. It's developed. A lot of changes have come into force, some today, some in the new year. But more or less, in a nutshell, it's got a lot more attractive for employers to sponsor those on a skilled visa to come and work in the UK. And I say this because at the moment, a UK-based employer would need to show that they've tried to recruit locally, that they've tried to, they've advertised the post and they've conducted interviews and so on. Again, this requirement to explain why they couldn't recruit locally is no longer a requirement from the 1st of January onwards. And more or less also, traditionally you needed, or at the moment you need a bachelor's degree to come into the UK and be considered for a sponsored work visa like this. That no longer will be the issue from the 1st of January 2021 as well. So we find that this visa will be a much go-to visa for a lot of young Australians, perhaps, who want to get their feet in into the UK based on being sponsored by a UK employer. Again, with this visa, you can bring in dependents, wife, husband, and children under 18, and they'll get the same sort of visa duration as yourself. So that's the work permit route there. Okay, coming away from British nationality and British immigration, Irish nationality. So a lot of you guys on this webinar may have Irish-born grandparents or parents, so that this might be relevant. I won't spend too long on it because it's fairly straightforward as compared to the British nationality side of things. Yeah, so we got by descent and double descent. So again, this is where you have a parent or grandparent, not just born in the Republic of Ireland, but even Northern Ireland. And of course, as you'd have seen with British nationality claims, the legitimacy is an issue. So you would need to show a legitimate birth if you're trying to claim it through descent, perhaps a parent who is Irish or a grandparent who was born in any part of Ireland. Transmission it just relates to us recognizing that there are people out there who don't have Irish-born parents or grandparents, but perhaps the relevant parent or grandparent lived and naturalized or registered as an Irish citizen living in the Republic of Ireland, and then have children born out of the Republic. Again, that could also translate into Irish citizenship for the next generation. Of course, Irish citizenship gives you the ability to continue sort of obviously living and going to Ireland and the rest of the EU nations, because Ireland is very much still part of the EU. But also more importantly, you can come into the UK, because unlike EU citizens who from the 1st of January 2021 will not be allowed to just sort of settle here just because they're EU nationals. Irish citizens have a different treatment there, and they will always be allowed to settle in the UK without visa restrictions. So another sort of attractive point on why you would probably want an Irish passport but be looking to settle in the UK. So that's all from me. I hope you guys have enjoyed that so far, and I'll hand it over to my colleague John. Thank you very much for listening.
Thank you, Phil. Thank you, Michelle. Very interesting indeed. Okay, the question probably on most, and judging by the questions, is the main question is, do I have a claim to British nationality? What we will generally ask you to do, even if we ask your questions here, is to go onto our website and complete our online assessment. I've posted a link in the chat that you can use to access it. The online assessment is quick. It will ask for your basic family information as per the Q&A, your parents, your grandparents, place and dates of birth. Our specialists will have a brief look at that information, similar to what Michelle and Phil will do at the end during the Q&A, and they will give a brief opinion on the likelihood of you obtaining British nationality. So once you've done the assessment, you can order a free British passport review at the end of the assessment. That British passport review will give you one of 5 results. One is remote. The chance of you obtaining British nationality is 5% or lower, so it's probably not worthwhile pursuing it further. You can get a definite result. It means we can identify, we immediately see a route to nationality, and we can move straight forward to assist you with an application. You then can get one of the other 3 answers of unlikely or unclear. Generally, that means we need a little bit more information to give you that opinion. And then, of course, you can get a likely result, which we feel you in the 90 to 95% category. Now, those bottom 3, likely, unclear, and unlikely, generally lead to a status trace. If you do fall under the unclear or unlikely answer, as I mentioned, it is generally we need some more information from you. There is an option to do a phone consultation with Michelle. The idea of that phone consultation is for him to have a better look at your family tree and move you from unclear or unlikely into a likely position, where we can then move you into a status trace. Or there's a possibility that he can then see that it is a remote chance of getting British nationality, and then he can possibly give you advice on EU, Irish nationality, or UK visas. So, sorry, moving on to the Q&A part of our session. There's been a number of questions coming in. Thank you very much. We'll start with one from Adam, born in Adelaide. Says his maternal grandparents were born in Australia. Sorry, Adam was born in 1945, and his paternal grandfather was born in Scotland. I'm going to make the assumption that Adam's parents were born in Australia as well. He hasn't posted it.
Okay, John. So
Hi.
Sorry, Phil.
There seems to be a problem with your audio, Phil. Apologies for that.
Okay, let's start again. Is that better?
There we go. Yep, I can hear you.
Right, okay. So, Adam, you're born before the 1st of January 1949. And the 1st of January 1949 is one of those key dates that we were talking about. So you're born before the British Nationality Act 1948 comes into play. This isn't particularly helpful to claims to citizenship in the modern day from Australia. And I think from what I gather from John, if I'm not mistaken, that you're closest connection to the UK is paternal grandfather being born here. Is that correct, John?
Correct.
Yeah. So I'm afraid on this occasion, it's not going to lead to a claim to citizenship for you. It will give you that option to acquire a UK ancestry visa. And I should say on that point that age is no barrier to applying for that type of visa. So the ancestry visa gives you a right to come into the UK and settle here. The visa is issued for 5 years, and you're supposed to be in employment during that 5-year period. So the assumption might be that those who are retired can't qualify. That's not the case. As long as you can prove that you have enough money to live on in the UK, and you participate in some sort of employment, even if it's just part-time or voluntary work, perhaps at a local charity shop for a day or two a week, that would meet the requirements of the rules. At the end of 5 years, you would get a permanent resident status and then could look at naturalising in due course from there. But I'm afraid there's no direct claim to UK citizenship in that case that I can see.
Okay, thank you very much, Phil. The next question is from Susie, born in Australia in 1968. Her father and both his parents were born in Australia. Susie's mother and grandfather were born in the UK, and her grandmother was born in Italy. She does mention that her mother gave up her UK citizenship in about 1971.
All right, John. Thank you. Yeah, Susie, I saw your question earlier, and I must say that, of course, if your mother has formally renounced her British nationality, as compared to just letting her passport expire. So I don't know if you're 100% sure she's renounced her British nationality, by which I mean she's actually gone into the British post abroad or the consulate and said, look, I'm going to renounce my British nationality, and that's resulted in a renunciation certificate. If that is the case and that renunciation happened before your birth, then yes, so you wouldn't have a claim through your mom to register as a British citizen in the modern day. But I would strongly suggest that you make sure, because it's very rare that we see those in terms of those renouncing British nationality in order to continue their Australian citizenship. I know there were some dual nationality restrictions in the past. So I can't be, you could be right, but letting a passport expire is one of the biggest things I've seen people mention that my mom renounced. But actually, in reality, the mom just never renewed her British passport or never really applied for one. So just be 100% sure about which one it is. And if you need our help to ascertain whether your mom has indeed renounced, then we are on hand to give you advice on where to look for a renunciation record, perhaps. All right. But if your mother hasn't renounced and she just let her passport expire, then we know she's actually continued as British and was British on the day you were born because of her UK birth, and you would have a likely claim to register as a British citizen in the modern day. All right.
I think I can probably add a bit for you
Yes.
there, Michelle.
Sure.
There was no legal requirement in the 1970s for a British national to renounce UK citizenship at the
Right.
point of becoming an Australian. So although the same wasn't true, the opposite way round, that an Australian citizen formally and voluntarily acquiring UK citizenship was a problem. That
Sure.
if you were, that's an issue. But the other way around, if you're British already by birth, there was no requirement for you to give it up in the 1970s. So the likely position here is that the citizenship is still intact for the mother, and the claim exists for for Susie, I think you were talking to.
Yes, correct. Good.
So if you can do our online assessment and get in touch, we'll see how we can help you. The next question is from Jamie, born in 1972 in Australia. Her mother was born in the UK, and her mother's parents were also born in the UK. She's inquiring about her son, who she's trying to get citizenship for. Jamie hasn't given us a date of birth, but so Jamie, if you can just provide your son's date of birth, please.
Okay, well, Jamie's one of those people who was affected by gender discrimination in those early years. So she has a claim to acquire British nationality through a formal application now, if she wants to take that up, or indeed if she already hasn't done so. She also would have had a status called the right of abode, being a Commonwealth citizen with a UK-born mother in the past. So she would have had the right to come to the UK at any point, even before the new legislation that had come in to combat gender discrimination. Jamie, okay, I see you're Jamie in the male sense, not the female. I apologize. Same thing applies on that. There's no change in terms of your rights there. So you still have that right to claim through your mother if you haven't done so already. Okay, so for your son, so the date of birth, 6th of November 2005. So still under the age of 18, which is a good sign on this. So we're then looking at a claim in the second generation by descent. So we have to go back to those other slides. So Jamie, have you worked in the UK before? Have you lived in the UK before? Would be a key issue here. Okay, that's a no. Okay, so it would leave you with the only other option being if there'd been Crown service in your family line there, which is something you haven't mentioned yet. So I'm going to assume that's a no. So, Jamie, yep, you're right. Your son will qualify for an ancestry visa later on becoming an adult. It has to be 17 years of age at the earliest point to acquire that. So, although there's no claims British nationality here, the ancestry visa will become available when your son's an adult. Equally, if you decided to move to the UK now, your son would have a right to claim a status as your dependent, either with you having the right of abode or having full British nationality. So yeah, after 17 years of age, ancestry visa is definitely possible, but no direct claim to citizenship, I'm afraid.
Okay, thank you.
Okay.
I'll move on to Cameron, born in Australia in 72. His mother was born in Scotland and father born in Australia. His father's maternal grandparents were born in the UK. He does say that he had right of abode in one of his previous passports.
Yeah, that makes sense, John. Yeah. So Cameron, yeah, you would have had the right of abode because you had a UK-born grandparent and who probably was British at the time you're born, and by that I mean your mom's birth in the UK and you being a Commonwealth citizen. So entirely correct for you to have held the right to abode, or still be holding it, I should say, even though you might not have a modern day vignette on your current passport to reflect you have the right to abode, but actually in law you still are someone that holds the right to abode. In any case, I guess the question for yourself is whether you can claim British citizenship, and I think the answer to that is yes, because again, much in the same way why you're given, the right to abode British nationality wasn't allowed to pass on in the female line, as you probably heard in this webinar, but yeah, to cut a long story short, I mean, absolutely, you would have a claim to register as a British citizen through your UK-born mom. So please get in touch with us, and we can give you a quotation for taking that forward for you. All right.
Okay, excellent.
Oh.
The next question is from Francis and his wife Elizabeth. I'm going to give you Francis's brief family tree first, and then Elizabeth. So Francis he hasn't said where he was born, but his father was born in the UK, and he was born in 1963.
Okay, Francis. Well, assuming your parents are married, then you're going to have a direct claim to a UK passport if you don't already have that already. If your parents weren't married, then you do have the option to apply to the Home Office to get that right instated now. So whichever way you look at it, the end result will be you will qualify for the UK passport. So your wife is Elizabeth. I think that's next, John.
Yep. So Elizabeth was adopted at 18. Her father born in 1911 in the UK. Her paternal grandmother was born in the UK. And then her father, she says, was stationed at RAF Maralinga, and he came back to Australia in 1964. There's not a lot of, it's not complete detail there.
No, so the adoption, when we're talking about the father here, Elizabeth, born in the UK in 1911, is that your birth father or your adopted father?
I don't know if Elizabeth is online. Elizabeth, if you are, if you can just post that question, that answer, please.
Okay. Probably not still online, in which case, I mean, both of those, the place.
There you go. Birth father.
Okay, birth father. Okay, so that's great. So you would imagine that the rights to citizenship by descent from a birth parent might be extinguished with the adoption, because of course the adoption normally transfers parental responsibility and all rights to the adopted parents. Doesn't work that way with British nationality. In fact, you can still claim from the birth parents, although evidence can be a little bit tricky sometimes. So Elizabeth, from what I can see there, again, you've probably got a claim either directly or indirectly to a UK passport. If your birth parents are married, it would be a direct claim to the passport. If they're not married, it would be an application to the Home Office first. And I suspect you'll need details of the adoption order and the court papers from Australia if the adoption took place over there. So I think probably one way or another you'll have a claim.
Okay.
Even if the event that you didn't have a claim to citizenship, there'd still be a claim to the right of abode there for another reason, which I won't go into. But that one way or another, you'll have the right to live and work in the UK permanently.
Okay. We have a question from Jordan, born in South Africa in 1997. His mother was born in South Africa. His father was born in Australia, but lived in the UK for 11 years, between 65 and 76. His maternal grandparents were South Africa, and no mention of his father's parents.
Okay. John, does Jordan mention his dad holding a British passport? Does he use the word British father or anything of that nature, John?
No, he just says
No.
he lived in the UK and he moved
Okay.
back after less than a year after being born in Australia.
Right. Okay. All right. Well, I think for Jordan, I think the real turning point is going to be what his father did whilst he was here for those 11 years. If obviously, I mean, you can tell what I'm going to say next. If obviously Jordan's father's taken the step to register as a citizen of the United Kingdom and Colonies, which was the form of British nationality available in that time period, then I do think that Jordan would have a claim to a British passport in the modern day, especially if that registration most likely took place whilst the dad was living here, and through just UK residents, one can do that. If they were just here for 5 years, one could do that. So I do think it's for Jordan, it's really to find out if his father picked up any British nationality whilst he was living in the UK for those 11 years, and especially because it would have happened before Jordan was born. So I do think there's a little bit more information we need. But Jordan, if your dad did pick up some form of British nationality or any British rights, worth getting in touch with us. We can examine what exactly he's picked up and whether that can be passed on to you to claim a British passport in the modern day.
Okay. Thank you, Michelle.
Morris.
We're running out of time for the Q&A, and I see we have had a lot of very good questions. Interesting. I think we're not always able to get to all the questions because of the number of people that attend our webinars, but as I mentioned previously, if you can complete our online assessment, which I'll copy a link again now, then complete it. You can get in touch with one of our consultants. You can contact us via our website, through WhatsApp, through email, or via the telephone. I've just posted that link there now. If you'd like to, you can post your question to us on either of those platforms as well, and we can have a discussion and go further that way as well. So thank you very much, gentlemen, for your presentation and your time. Thank you to all of you that have joined our webinar. We hope you enjoyed it.
Thank you.
Thank you.
Bye.
Bye-bye.